Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another episode of the Probate Realtor Show. Today, we are joined by a special guest, which has been with us a few times already, Kevin Sayles. Kevin, welcome to the show.
Oh, thank you for having me again, Matias.
Kevin is Vice President of Lawyers Titles, and he's an expert in the sale on the title end of properties through probate. One of the things we're going to talk about today, Kevin, first thing we're going to be chatting about is naming of a trust. Kevin, what can you tell us about naming your trust?
So people can name their trust whatever they want. And a lot of times we see names like John Doe, trustee of the Doe Family Trust. That's what we see as the name of the trust. Perfectly fine. We have no preference or no real consideration as to what you name a trust. Mm-hmm. But the one thing that comes into play is when the name is something where we can't tell whose trust it is, then we are always going to have to see a copy of the trust. So for instance, John Doe, trustee of the Doe Family Trust, and he's selling his property. It was his property beforehand. He put it in that trust. Now he's selling the property as trustee of the trust. We would not even have to verify a copy of the trust. We would view a trust cert, which I think we talked about in another episode, and that would be it. But there's also—
Just to refresh the memory of our audience, what is the trust cert?
The trust cert is a document where it's usually 1 or 2 pages where the trustee of the trust verifies the trust is still in place. You know, this is the name of the trust. I am the trustee. Kind of, you're just verifying that, yeah, this trust is still real. It's still in place, and I'm the person in charge of it. You just kind of verify that on a 1-page document. So typically when a person, Mary Smith and Mike Smith, husband and wife, right? And they put their property in their trust. Mary Smith and Mike Smith, trustees of the Smith Family Trust. When they sell that property, we would review their trust cert. They say everything's still in order and in place. Mm-hmm. They would be fine to sell just with that. Whereas if they put their property in a trust that has a different name, I've seen some where it's like the 123 Main Street Trust. When it's not a trust where we can tell who the trustor is, then we're going to have to see a copy of that trust. So as a title and or escrow company, the name of the trust could make a difference. It would make a difference when we have to see the trust or not. Got
it. So sometimes for added extra privacy, some of these trusts don't have the family name on it, but be prepared if that is the case, that the title company it will not be sufficient to provide a trust a trust certificate. They may need to see the entire trust.
That's correct. Yeah, and you bring up a very good point. It's common with actors or public figures, elected officials. They don't want their name on title because then you have groupies and people that would just show up. So they'll put the property in trust. Maybe they have a business manager as the trustee, and the trust name doesn't say, the actor's name. It says something else. Perfectly fine. We deal with those all the time. It's not an issue, but we are going to have some information because ultimately the IRS, the CFPB, a lot of entities want us to make sure we know whose property is it that we're selling. So there's some documentation we may have to review. That
makes total sense. Now let's talk about something else that it's often overlooked. We always talk about, trust and probate. I sell trust and probate. We specialize in trust and probate, et cetera, et cetera. There's something very important that it's also handled at the probate court, in the probate courts, which is a conservatorship.
Yes.
Kevin, what is a conservatorship?
So conservatorship is when a person who is living is not able to handle their affairs. It could be physically, mentally, for whatever reason, they cannot handle their affairs. So the court puts a conservator in charge of their estate. You could have conservatorship over just the person, meaning I could have medical, I tell what happens medically or what food they get, or I can deal with the doctors and stuff like that, or conservatorship over their estate, which is their property, their bank accounts, their stocks, their bonds, that kind of thing. So the court puts someone in charge of that person who can't handle their affairs in charge of their stuff.
Thank you for that. Now, if anybody has seen when somebody is appointed in charge of a estate, whether it be conservatorship or whether it be probate, if you have ever seen what we talked about earlier, letters, right? That's what they're called.
Yes.
The court's decision, and it's therefore, the court order of who is in charge of the estate. These letters underneath, I think it's like on the third line or something underneath the block, the second block or something, they will have a space for conservatorship. So in this particular case, for the box to be checked, those letters are if somebody wants to sell a piece of real estate that is in conservatorship. I've seen this happen many, many times. The conservatee requires medical care, and the conservator says, in order to, we need to start selling off some of the assets in order to provide full-time care, because the person is incapacitated. What does a title company need to see to make sure that the transaction goes smoothly for both seller and buyer?
Conservatorship sales are always going to require a court order. Right. Sometimes it is a court confirmation. Sometimes it is just an order for a private sale. But one way or another, there has to be a court order for the sale that gets recorded with the sale documents. So in addition to a deed from, Joe Smith, conservator of the person in the state of blah, 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 in addition to a deed from them, from that conservator to the buyer, there's also going to be an order that's approving and saying, yes, sell this property, to whomever it may be.
Exactly. And once you obtain that order, then you can close the escrow.
That's correct. That's correct. Yeah, we have to have that order. And on a conservatorship sale, we're going to require a certified copy or the original of that order with the wet signature. And the reason is that we actually record that. We put that on the public record when the sale happens. So that document gets recorded. We need a certified copy of that order along with the deed from the conservatorship to the buyer.
Now we know that's, we're not here to, investigate the philosophy behind the law, because we know that's the law. So, whenever I say, Kevin, we're ready to close, say, Matias, do you have the order? I say, yes, the order just made it in, escrow will send it over, or whoever the attorney is sending it over. What do you feel is the reason behind the needing of court involvement in a conservatorship? Because, the public is becoming now aware of what conservatorships are because it's been in the news last year, et cetera. Why do you think the court is involved?
Well, this is just my opinion, but it
Right.
logically makes sense. And I believe I got this opinion from an attorney about, talking about the conservatorship court. But think about it. Let's say someone gets in a car accident and now they're in a coma and they look like it, it's very grim, doesn't look like they're going to survive. Maybe the family needs to sell the property to pay for the medical expenses. There's equity in the property. They got to do that. Well, the reason that order has to be involved is because the judge or someone needs to oversee this. We don't want every time someone is conserved in a conservatorship, we don't want their property sold every time, because what happens if they come out of that coma? What happens if they have dementia, but there's, a cure tomorrow comes out for dementia. Now people can take this pill and dementia goes away. We don't know what's going to happen in the future. So since the person is still alive, we don't really want to be getting rid of their stuff. Yes. And so I think that's the logic. That's my opinion of why there is a court. We talked about probates previously. Those don't have to have a court order all the time for every single one in terms of saying, yes, sell this property this way, that amount. Whereas with a conservatorship, there's always going to be an order, approving or ordering that sale of the property.
Yeah. So just to refresh everybody's memory, with a probate, you have two kinds. You have limited authority and full authority. With limited authority, you will need a court order to sell your property. With full authority, you will not need a court order to sell the property, but you're still reporting to the court and you're still subject to certain notices that you have to give out. Without touching too much upon what we've already talked about, I would love to, even though this is more of a rare occurrence, Kevin, I would like to talk about commercial properties. Because, when we talk about probate, people are always thinking, hey, it's my mom and dad's residence or, their apartment. In truth, even though, a lot of these properties, when it comes to probate or a conservatorship, they have a tendency to have been put, commercial properties have a tendency to go into a company to begin with. What are the steps to do when a property is a commercial property as in probate?
Yes, so that's a very good question. If like you mentioned, most of the time, or it's very common for people to put commercial properties in some sort of entity. That way, there's kind of a succession plan. But when people don't, if there's a commercial property and the property is owned by an individual and it goes through probate, then the process would be the same. But sometimes you have a situation where John Doe, the owner, created Doe Enterprises. It's incorporated. It's a corporation, and the property is owned by Doe Enterprises. Well, one of the things that has to be considered is a regular probate case does not give that administrator power over the company property. So there's usually an extra step in there that has to take place for that administrator to act on behalf of that corporate property. So there's an extra step involved. And if a family was, going to an attorney for a probate case, they should make sure they make mention of that, hey, we had this corporation, his properties in that corporation, et cetera, because corporations don't die, right? They can survive. If you think of any corporation, not that I would wish this on anybody, but Starbucks, Bank of America, any company that you can think of, if the president of that company dies or the CEO of that company dies, the corporation goes on.
Exactly.
And it's like that with entities. So that's why there's an extra step that has to take place in some documentation that we have to verify in order for an administrator to act on behalf of a corporation or an entity property.
So this is very important. This is a very important point. If you have been appointed administrator or executor of a person's estate, do not take it for granted that now you can act because they were the owners of a big company, then now you can also run the company. There are other actions or liquidate the assets or whatever it may be. A lot of small business owners have maybe an LLC that they have set up to run their business. And so if there are assets in the LLC, like most notably would be a place of business, like a storefront or a commercial location, there are extra steps that are needed. So make sure you do those steps and make sure you surround yourself with a trusted advisor, because you don't want to be in escrow and then find out that, guess what, you can't sell this property. That happens all too often, unfortunately. You got to make sure that when you are selling a commercial asset, the person that's selling the asset has the authority to sell the asset. So good. Now let's talk a little bit about the documents. The documents just in general, like when you're closing a probate, Kevin, let's talk about a list of documents that are necessary that, your clients and, the real estate agents that are involved in the production should be prepared to provide and gather. We've talked about some of these documents, but now let's bundle them all together so that our audience can kind of see okay, here's what we got. Here's what I got to get going.
Absolutely. Absolutely. So if we're selling a probate property that is going through the administration, meaning grandma died, there's a current probate open, and the administrator of the state is selling that property, the documents are going to be determined by the type of probate it is. So if it's full authority, then we're going to want the letters testamentary. We're going to want a copy of the notice of proposed action. And by letters testamentary, that's either letters of administration or letters testamentary.
Right.
Right. So the letters, we need the letters, we need the notice of proposed action. And then we always want an email or a letter from the attorney saying that there are no estate taxes due. Some probates, if the assets are sizable, there might be estate taxes due. We rely on the attorneys providing, information saying that there are no estate taxes due in this case, or there are not. There are or are not, depends on whatever the situation. Most of them there are not, because most time when people have estates that sizable, they do some sort of planning. So that email, that's required because we have to know those things. And if estate taxes are due, they become a lien secured on the property, so they have to get paid out of the sale of the property. So that's with full authority. With limited authority, we want, and by the way, on the full authority, we typically want a certified copy of those letters. On limited authority, we just want a plain copy of the letters. It's an email. We require a certified copy of the order confirming sale. That document actually gets recorded, so we have to have that certified copy. Certified copy of the order confirming sale. That's the order that when the confirmation hearing happens and they approve a buyer, that's the order that comes out of that hearing.
Exactly.
And the other thing is still the same email or letter saying no estate taxes are due.
Very good. So this is just something, you brought it up, so it made me think about it. When you have limited authority and you require a court confirmation, very few people understand that the sale is subject to overbidding. And what does that mean? That means that somebody comes to court and they say, I'm willing to pay more. They get qualified by the estate and are authorized to pay, and then they're willing to pay more. Now, this person who is the overbidder, who bid on the property, does not necessarily have a contract, a purchase agreement. Their contract is the court order, which we will issue that day. That's why it's so important that you get your vesting straight if you're buying probate real estate in court. Get your vesting straight, because Kevin, when he looks at that order and he says that you're closing in ABC LLC, and you say, well, you know what, we just opened another one. We closed, it's 123 LLC. Well, guess what? A judge order to close in that name. So this is I think it's a very important point that we need to let our audience know, because some of the people who follow us, maybe investors, maybe people who are interested in buying probate, which leads me to make a shameless plug for Kevin's book, Probate Real Estate Sales 101, which Kevin is very modest about. He never talks about it, but it's a wealth of information. It's available on Amazon. Sorry, Kevin, for plugging this book. I don't want to embarrass you, but it's a wealth of information. Let's just talk about really what made you decide to write a book on probate.
Well, I also want to comment on what you said. That is so important, that because in court they're going to say who's buying, what name are you buying the property, and that goes in the order. That order is going to be followed by escrow. That order is going to be followed by title. When it's in the order, whatever is said in the courtroom, this is who's buying it. That's what has to happen afterwards.
Yeah.
So very important that when people are bidding, they know I'm buying it in XYZ entity when they get in there. But
Exactly.
But you asked the question. I mean, the whole reason I wrote the book is just to have information out there so that I thought it would make my job easier. I thought rather than answering the same questions over and over, I said there should be a resource for people. People should be able to go to a book and go, oh, notice of proposed action. Here's what that is. Here's the time period I have to wait after that's filed in order to close. I just wanted that information to be out there.
Very nice, very nice. Let's talk about, we chat a little bit about this, and you told us that you used to work for a bank who kept their records on location, and then you started to go in, and unfortunately they were burned during the riots, and so you had to start going to the city, etc. When you started in title, this is what I'm interested in. Did you start in title knowing that you will be heading toward the probate world, or is this something that kind of like you already knew how to get these documents, you were familiar with the way it worked, so you might as well illuminate me on that process? When you went to title, were you like, I'm going to be on title and I'm going to do trust and probate, or were you like, no, I'm just going to do title and then
Yeah, when I started in title, I had a lending background, and the company that I worked for hired me as a training manager. They wanted someone with a lending background that knew title, and I knew both. And so I started it that way. Within 6 months, I was a sales manager and out as a rep. So I was a rep that had my own sales team. I had about 8 people on my team at one point. So the point with all that is I had no idea. Like I didn't realize I knew so much about escrow until I joined the title company and I sat with an escrow officer. I think we went in early, like at 7 a.m. and I sat with the escrow officer to see all the things they do. And I remember going, wow, I didn't know that there was a person that did all that, because the bank I worked for, a lot of the escrow functions we did ourselves. We did the signups ourselves. We scheduled all of that. We reviewed the prelims ourselves, all that kind of stuff. So I learned how much I really knew about this business when I got to the title company and started working in it. And the same goes with the probate world. When I got my first probate sale transaction as a title rep, I realized that everybody doesn't know all that I know about how this process works and who the administrator is and blah, blah, blah. And so in going through transactions, I started realizing, wow, I know more about this than the average person. And I started doing workshops to help people understand, here's how you close a probate sale. And that just grew, and I started realizing how people didn't know this information. And it was constantly surprising to me that the information that wasn't readily available out there that I thought more people should know, because it makes our transactions go a lot smoother. Thank
you for sharing that with us, Kevin. Let me ask you a question. As a title officer, and we touched upon a lot of this, but I just want to ask you to, because I think it's a very telling question, because it's kind of open-ended. As a title officer, what problems do you like to solve? What are the challenges that get you ticking and be like, Oh yeah, I'll take care of that one. I can do it.
Yeah. So okay, so I'm a rep, and I like to
Oh,
see.
excuse me. You're right. As a title rep.
Yeah,
Yes,
yeah.
yes.
I really like to dig into situations where the client has been told no by someone else. I
Okay.
get that regularly, where someone calls me, maybe they know my expertise and they know my background. They go, "Hey, the title company we're with can't do this or won't do that," or whatever the situation is. And I love it when they give me an opportunity to look at it. I'm smiling so much right now because I have one that I received on Friday. And I said, there's some documents I need to pull up. We'll get back to it on Monday. We've gone through it. I've been reaching out to an attorney to get some more information. And it looks like one that we're probably going to be able to do. And it's a challenge because I feel like I'm doing something others can't do. And it makes me feel good about the work that I do in my job.
That's awesome. That's awesome. So you like a challenge. You don't shy away from a challenge.
Yeah, I do. I mean, I probably could make my life a lot easier by not being that way. But yes, I do like a challenge.
Very
I like
nice.
easy ones too. So if any real estate agents or anyone's out there, send me the easy deals too. But yes, I do like a challenge.
Okay, good point. Good point. All right. Guess what? Before I let you go, I got some fun questions for you. For our audience who's been following us, you already know I have 30 questions, which now I feel like I have to expand to more than 30 questions because I actually have a lot more. But in a former life, I used to run a social club for fun as friends, and we had all these questions that we asked each other. And these are from that. They were gathered from various interviewers and et cetera, et cetera. Pick a number from 1 to 30, and I will ask you a question from this list.
I'm going to go with number 1.
Number 1.
Yeah.
What is the best thing that happened to you recently?
The best thing that happened to me recently. I'm going to go with this. So I have 4 boys.
All
One
right.
is grown and out of the house. 2 are away in college. So it's almost like it's almost an empty nest now. And very recently, we went to Las Vegas to go watch BattleBots. And we
All
all
right.
went out there. And the best thing about it was there was one evening where we had nothing to do and we were just sitting at a table. The food was not very good. We were at this place. The food wasn't very good, but the family being together, me and my 4 boys were all at the table and we were talking and laughing and joking and teasing each other and just having a good time. So spending that time with my family, thanks to my wife is very good about creating memories for us. And it's all thanks to her, but that's the best thing that's happened to me recently.
That is awesome. That is awesome. And as I'm sure some of our listeners have noticed, Kevin also happens to be a father of 4, as I am. So there is a special bond with him, with us, fathers of 4.
Yeah.
Okay, let's do one more. Pick another number, please. Kevin.
Okay. I think I did the first one, so I might as well do the last one. Let's do number 30.
Okay. All right. This is a good one. If you could be a professional athlete in any sport, what sport would you choose and
Okay.
why?
It's a very good question. I'm going to say this. So in my younger life, when I was in 2nd grade, I wrote you have these essays you have to write. It's basically you're answering questions. And
Yeah.
I said I was going to be a professional football player.
All right.
Played football throughout high school. I played football in college. I love football. I love to play it. But I also know there's some damage that happens. Nowadays, I played before we knew this concussion protocol, right? I know I had a lot of concussions and we didn't really realize it. So now with my 2020 hindsight, I would play golf.
Golf, there you go.
Because you could play golf into your 50s, 60s, 70s, and they make a lot of money and it's not so bad on their body. Yeah, I'd probably play golf.
Okay. All right. Very good. Very good. Okay. One last thing before I let you go. Obviously, your contact information are going to be in our show notes, but if anybody wishes to get a hold of you, how do they get a hold of you, Kevin?
They can reach me at this number. It's 213-364-3810.
Wonderful. Thank you so much for being on the show. It's been such a pleasure. We've covered so much. The beauty about this show is that it's alive, it's living. So if you have questions, you're out there, you can reach out directly to Kevin or directly to me, and we can assist you. And like I said, I'm just like Kevin. You can send me the easy transactions, no problem. But if you got a challenge and you run against the wall, just feel free to reach out because we may be able to make a difference. So, Kevin, thank you so much again for joining, and thank you everybody for joining. It's been a pleasure to have you. Do you have any parting words for our audience?
I would just say that, Matias, you do such an excellent job at this, and
Oh, thank
fun,
you.
and it's great to be able to get this information in the hands of people that need it. So thank you for doing it.
Thank you very much. Thank you, everybody. Have a great rest of your day, and we'll see you in the next episode.